On 24th September 2018, the then Inspector General of Police, General Kayihura, was dragged to the General Court Martial and charged with charges of failure to protect military equipments, aiding and abetting kidnap of Rwandan nations. General Kayihura pleaded not guilty to all the alleged offences. However, he was later released on a non-cash bail of 10 million non-cash. Other conditions against him included to report to court once every month, not to travel outside Kampala and Wakiso, and not to travel outside the country without permission from either the military court or from the military leadership. The bail conditions also necessitated him to report to court as and when is required, with the pending charges against him. On Monday this week, General Kayihura was shortlisted among the 13 high-ranking military officers to retire from active military service. Among them were 6 army generals and 7 brigadier generals. Their official retirement is scheduled for 31st August 2023.
The crimes that are still with Kayihura will not necessarily, as I've seen in some sources saying that the charges would be dropped. That's not a fact. It is only the court martial, which has the mandate to determine the matters before it, or for the prosecution before that court to drop the charges. Until that is done, even upon retirement, General Kayihura remains a suspect being charged before that court.
Therefore, if a person is charged or is alleged to have committed these crimes at whatever period, maybe 2017, 2016, 2015, they are not discharged of liability by virtue of retiring. You are only discharged of liability by the court which charged you, or by the prosecuting authority saying we've dropped the charges. Those are the only 2 ways where a person's liability is discharged. In this case, whether General Kayihura has retired or he has not retired, the charges can still stand because the liability is still there, and it doesn't matter whether he's a serving soldier or not. The most important thing is at the time when they were committed, that is the time when you are being charged, and so the charges can still continue. However, the way the court martial is used, many times it's not used as a normal court. Many times we've seen President Museveni, when he was campaigning in 2021, people in Gisoro asked him that please forgive our son, and the president promised to think about it. Yet the president, under our laws, has no powers to forgive a suspect. The president can only forgive a convict. That means that court martial, many times it's used just for purposes of punishing those people who possibly the president wants to be put away. That is why all the people who are charged with General Kayihura, I think some of them are out on bail. Nixon is just got out recently, Herbert Mohanji.
Although General Kayihura has been frequently reporting before the General Court Martial 6 years down the road, the cases against him had not commenced for hearing.
It's the same bad story that was presided over by General Kayihura. He's known to have been that person, a lawyer at that, who advocated for holding suspects before trial for 90 days. He's on record for having advocated for a law that a person can be held without trial for 90 days. It came to his part, and we saw him now crying foul when he was held without bail for 72 days without trial. Now, he's the same person now who, after all this time, is not being tried. I think that sends a message to him and to many others who are in power, that one person's right is not any less than the other. The way you treat a person when you are in an office of power may turn around to be the same laws that catch up with you. So, General Kayihura, like other people we've talked about, it is wrong. Whether it's about General Kayihura or other suspects. Like recently we've seen what happened to the Omusinga. After 6 years, we are talking about General Kayihura, but we have Omusinga who was arrested under General Kayihura's reign. Now, failure with the prosecution failing to have evidence, even to sustain a prosecution against him. And this was Kayihura's time. Now the same General Kayihura, to date, there is no process. It speaks to 2 things. that sometimes some arrests and charges are political in nature. They are politically instigated. That not a person is charged, not that the state believes it will sustain a charge against him, but the state knows it will hold him for some time on those charges politically. People are in prison when there are no plausible charges that can be sustained against them, and they remain there even for 6 or even 10 years. So this has to be checked. This is a story to be told by Kayihura now that he's even in private practice. He would be best suited now, even with his human rights record, which is not good enough, at least now to clear his image by advocating for at least a better human rights record. He is on sanctions as we speak for having gravely violated rights of suspects, torture, inhuman degrade. You know, I would not want to say that on record that he committed these crimes, but it's widely believed that he did. Under his reign, there was a lot of torture. Some of us were victims. We are not saying this because we are victims of his torture chambers.
If you try someone 3, 4, 5 years after the alleged offences, one, if the person committed the offence, there's a high likelihood that the witnesses would have either moved or died or lost interest. That means that a criminal will go scot-free due to lack of evidence.
At the helm of his service as Inspector General of Police, his reign was characterized with alleged human rights violation, and the situation got worse when the US and the UK governments imposed the sanctions against him.
Yes, they have an impact because the background is that these are people sometimes who are very powerful and they can't be punished under their laws. Maybe the president is a commander-in-chief of the army, is the Inspector General of Police, and he's punishing, he's torturing the citizens, but he can't be punished under the local laws. And then two, maybe you don't want to go through the international process, which is also bureaucratic, of bringing up charges against this person. So the intention of the US Senate, when it was passing this act, was that let us do something which sends a message. It's just to say, we don't associate with you. Internationally, it's called soft law, that if we had it our way, maybe we would do it stronger. But we don't want to associate with you. Even the people we associate with should not associate with you. So many times we find that if the US denies you a visa on those grounds, most of the EU countries also deny you a visa. Then they sanction you in terms of economic money transfers. You cannot send or receive money. You cannot deal with electronic transactions. So it's meant to send a message. It's deterrent. You may say that yes, it may not be compared to a person maybe who has tortured people, who has killed people, but it's just a sign that this is the least we can do under our powers for now. And it's a step. It's a good step in the right direction.
Sanctions are not to the office. Sanctions are to the person. And they are partly economic. An economic sanction is on the person of Kayihura. So those sanctions will not be dropped. The charges will not necessarily be dropped by the retirement. All that we have to wait and see is whether the state can sustain such a charge. Because there's been this argument, a person who is not a serving officer, would that person still be charged and tried by the military court? Of course, General Kayihura has been a proponent of saying such people can be charged, because it's during his reign when such people started being presented before the court-martial. And the orientation actually started during his time. At a time when we saw a serving military officer serving actively as an IGP, right from General Katumba Wamala, that is when we saw the orientation of having these generals serving as IGPs, preferring to take people to the court-martial other than the ordinary civil courts. We are still opposing this. We are awaiting a decision of the Supreme Court in these matters. I may not be at liberty to have a conclusion on whether it should be tried there. But if the Supreme Court comes out with that decision in favor of our petition, that a person who is not a serving military officer may not be tried by the court-martial, maybe the files may be transferred to the ordinary civil courts. We are waiting to see what will happen. Yes. It is one of those means we've been advocating for as human rights advocates that more sanctions should be really put on some of these officials, because they bite, by the way. They bite. They assist a lot. You've seen some of them now acting cautiously whenever sanctions are put. No doubt, no doubt. It's one of those means out of the many. Prosecution, sanctions. I think I'm an advocate of more sanctions against perpetrators of human rights violations, especially torture and degrading treatment, the sanctions for which General Kayihura is serving.
With the increasing foreign sanctions against his personality at that time and other military officers, legal experts say partly this has helped in addressing the gross human rights violation that were being perpetrated by the men in the uniform who are charged with the mandate of keeping land order in the country.
So the intention of the US Senate when it was passing this act was that let us do something which sends a message. It's just to say we don't associate with you. International it's called soft law. That if we had it our way, maybe we would do it stronger. But we don't want to associate with you. Even the people we associate with should not associate with you. So many times we find that if the US denies you a visa on those grounds, most of the EU countries also deny you a visa. Then they sanction you in terms of economic money transfers. You cannot send or receive money. You cannot deal with electronic transactions. So it's meant to send a message. It's deterrent. You may say that yes, it may not be compared to a person maybe who has tortured people, who has killed people, but it's just a sign that this is the least we can do under our powers for now.
But in serving such sanctions, in having faced the wrath and the injustice meted out by the state against him and many others, he should repent. He should actually confess to Ugandans and repent by even practicing human rights, cases, because now he's a private lawyer. He should be that person to come out clean and really turn around. I believe where he has been, it's not been easy for him. But that even the state did not want to retire him says a lot. Before I see him being retired officially, because several times we've seen his list coming up and being dropped. So all this speaks to something. It's a political game within the institution, which we have no hand over. And whatever he does, of course, Ugandans really are not vengeful. We welcome him to the civil society. We welcome him to the bar practicing as a private lawyer. And we shall join him. We shall not really go after him. We believe if he comes and is repentant of all that he did to Ugandans, I believe Ugandans will not really follow up some of these matters. And for your information, some of these matters are in the ICC. There are matters up to the ICC which were filed. I don't know their fate, but even if charges are dropped here, it does not necessarily mean that he's a free man. There are charges beyond the jurisdiction of Uganda.